What's up, everybody? Welcome in. We are going to watch an emergency motion hearing. I've never heard of an emergency motion hearing in my life. This is for Donna Adelson, the Matriarch Mastermind murder trial. And I know very little about this case. I probably know more than I do about some of the cases we do. But I did not watch her son's trial. And I haven't watched any of the pretrial hearings, but we're going to do that this week. We're going to get caught up on the pretrial hearings. And I'm going to maybe watch some court TV shows and try to maybe learn a little bit about her son's trial. I don't know. Well, of course, we don't have to know everything, because whatever they present to the jury is what they'll need to know in order to convict her or not. So it's not like we'll be lost, but still, I like to know a little bit of backstory. And this one is a pretty big backstory. She was arrested at the airport trying to flee the country to Vietnam that does not have an extradition treaty with the U.S. So she was not coming back. That is consciousness of guilt right there. So, and I'm still waiting for them to arrest her daughter. But that probably isn't going to happen until after her trial, because they didn't arrest her until after.
Appearances on the record.
Georgia Kappelman and Sarah Catherine Dugan for the state.
Joshua Zoman and Jackie Fulford for Mrs. Adelson.
Good afternoon, Your Honor. John Morrow on behalf of the witness, Wendy Adelson, and my colleague Matthew Luca is with me as well.
Good afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor. No position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been two prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know, if we called her, she could rebut what has been said. It's not necessarily would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say Yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lawyer. I'm going to allow Ms. Fulford.
Oh, I'm sorry. I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
Wendy doesn't want to testify, is
Yeah,
what's
so
happening.
the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in
Wendy's
the
the
trial
emergency.
that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lawyer, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena and quashing the subpoena, Ms. McBanawan did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further,
We don't have tag team motions. So who's going to finish the argument?
Just a moment, Your Honor.
Wendy was given immunity in her brother's trial. She doesn't want to testify in this one.
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanawan would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor. The statement by counsel is patently incorrect and false. This issue was raised by Ms. Carras in the McBanawan trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA, and we respectfully request that Your Honor follow that ruling here. There is simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
Wendy's
Having
throwing, I
reviewed the
mean,
applicable authority on this issue, and also
Donna's
reviewed the
throwing
prior
Wendy under the
transcripts
bus.
on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time, but I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laurel, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this.
He quashed it? No. No. Are you kidding me? Okay. Dan Markel was murdered. He and his wife, Wendy, were lawyers. He was a professor at FSU in Tallahassee. I don't know where she worked. I don't know if she was a professor or practicing law or what. They divorced. Wendy wanted to move the kids to South Florida to be closer to her mom. And there was a custody battle. She wanted full custody of the kids and she wanted to move. They had joint custody. And Dan didn't want her to move to South Florida. And in Florida, what usually happens is if you move so many miles apart, you have to meet each other halfway. You have to keep your joint custody agreement. You have to meet each other halfway to exchange the kids, which is a pain in the butt. My husband's ex-wife did not do that. And he, for all intents and purposes, only saw his kids on holidays for a while. Anyway, so somebody murdered Dan Markel. And Wendy Adelson's brother, who was a dentist at the time, his girlfriend, who had been in trouble with the law and knew some people, got one of her exes to kill Dan Markel. So the hitman is in jail. She's in jail. Now Charlie Adelson is in jail. Wendy testified at Charlie's trial and she got immunity. But it wasn't like 100% blanket immunity. She could still get in trouble. So she was like very hostile on the stand and like she was not happy to be there at all. Like I said, I didn't watch the whole trial, but I've seen clips of her testimony. She was not a happy person. So this is why there was emergency motion hearing. Because they want to call her as a witness. The defense wants to call her as a witness. But they can't offer her immunity. So if she says anything that might exonerate Donna, it will inculpate, is that the right word? Her And the defense can't give her immunity. Only the prosecution can give her immunity. So basically, Donna wants to throw her under the bus. But that's why it was an emergency, because the trial is about to start. They're going to start jury selection tomorrow. So the trial's about to start. So she needed to get that subpoena quashed now. That's why it was an emergency. But it kind of sounded like he said that he was going to quash it, but then it also sounded like he was going to let her testify and take the fifth. So I'm confused. Wasn't that kind of like what it sounded like he said? That was weird. So I don't know. I guess we'll know when we watch the trial if she testifies. But I found the whole thing kind of funny because I think she was involved. If she wasn't involved, she at least knew about it. And I want to see her go down too. Because from what I understand, that he was a very beloved law teacher. Peter Tragos, he was one of Peter Tragos' teachers, and he loved him. And he had 2 small children that now don't have a daddy anymore, and that's not right. You know, even kids are not your belongings. Don't take your kid's other parent away from them. Whether it's literally taking them away or physically moving them away. Don't do that. Yeah, I don't understand what just happened. Because he did say he was going to quash it, but then he did act like he was going to let her testify too. So I'm confused. I mean, that's not anything out of the ordinary for me, but I was hoping that like they would do a news segment explaining what just happened, but they didn't. It just went to the bars, so I don't know. Okay, well, it's almost 2 o'clock. And I guess Court TV isn't streaming the Ali sentencing. Maybe if they play it later. And then tomorrow morning we'll finish Phil. And then tomorrow, I don't know how many of her hearings we've missed. But we might do some of those. I'm not going to promise they're going to be in the correct order. Because I guess maybe I should go through and figure out the correct order. That's what a good YouTuber would do. I never said I was a good YouTuber, though. Oh, that's the one thing I hate about doing hearings. I mean, how long was that? 15 minutes? Maybe? Not even? Like, when you go to stream a hearing, excuse me, you have no idea. It could be 5 minutes, it could be 4 hours. Like, you don't know when you go to do a hearing. It's just, you have no clue. So, unless you guys want to do one of our shorter hearings now, we could do that. Oh, why did I do that? I don't want to do that. I don't want to do that. Wait. Why are they still live, though? Oh, somebody explained it in their chat. The judge denied the motion for the defense. Wendy is allowed to receive immunity from the state. Her defense subpoena has been dropped. She can claim the fifth if questioned by the defense. Okay. So. There you go. So she can claim the fifth if she's questioned by the defense, and she can get immunity from the state. But the subpoena's been dropped. What? Wrong keyboard. Oh, dang. I put Wendy instead of Donna. I want her to get arrested so bad.
I'm Vinny Politan. Thank you so much for...
We'll skip through Vinny. I hope I don't get in trouble. I don't care.
I don't want to give it to you. Why do I have to?
Because my attorney said not to.
Why do I have to give it to you? This is evidence. She's under arrest. I have to go with. I have to go. I have to go. You don't have to go. I help you also. No, I have to stay. Please don't do this. You need to grab the bags. Take the bags. Yeah. You need to wait outside. Okay.
My husband's almost 80 years old. He can't come with me.
Please, can I go? No, you can't join me there. Oh, don't do this, please.
Please.
Oh,
Someone's got to help him get home. It's terrible. You can't do this. This is
Is that okay with you? Please. You don't have to have the handcuffs on. She's not going anywhere. Please. Please. Do you have anything in your pocket?
No.
Do you have anything of value in you?
No, I
Must you have a necklace on?
You wanna go?
You can take it off.
Yeah, take it off. Okay. And the earrings, the rings, take everything. You give it to your husband. Because once you arrive at county jail, they're gonna make you remove all that.
can I call my attorney?
You have a passport ready?
Where am I going?
Open company thing?
Where am I going?
You're going to the Dade County jail.
Dade County jail. No, this is right here, the one on 45.
Wait a second, please.
Miami.
Please. Okay. Do you have any other rings on? I'm sorry? Remove your earrings.
You take it right through this.
Yeah, let go back out and just.
You're making a mistake.
No mistake. It's two mistakes. And try to take the rings. Can you get this off for me?
Can you take it off, please, Donna? I don't want to hurt her. Please.
Just a minute, it's getting there. Listen to me.
Yeah.
I'll call.
Yeah, can you Uber, go home?
I will.
Take
I
it
will.
easy,
I will.
all right?
Yes.
Here,
If there's anything else in her person that she wants.
oh, it's coming, sweetheart, I thought, it's coming, just a
All right.
second.
Do you have her driver's license and checks?
I'm sorry?
Her driver's?
It's in my,
Yeah.
it's in my purse.
Yeah.
How could?
Yeah, then you could give it.
Sure. Do
It's
you need her
almost there.
passport? Or can I give it to the passport? Can I give it to
What's wrong?
Where is it?
It's in the blue and white, it's in the blue and white,
Yeah, but I'm gonna get her driver's license first. Yeah.
And the license, the address on the license is correct?
yes.
She needs all her.
When she goes to jail,
they work.
They're all in here though.
Yes, they work. If I take them here, what would happen is when you go there, they toss them out. So when you go to there, you will meet the nurse and the doctor, and then they'll work in conjunction with the hospital to get you whatever you need.
Yeah, but I don't have a list with me, I know what
Driver's license?
Yes.
I have a,
Is it multiple or is just one or two?
it's, no, there's a bag of medication in here. Is that what you're asking me?
She can take medication. No, I know. I was just trying to find out if it was like one or two. Yeah. If it was one or two, then she maybe could take the name.
Do you need anything else from her?
Can I ask
Or
you
we're good to
something?
go?
Can someone just get my husband outside and so?
I'll get him. There's a gentleman here with a system and anything.
I have to wait, hold on.
Let me.
Okay.
All right, so no, so I don't have the meds, honey, they're all in here. Give me 1 moment, please, hold on. 1 moment.
Sit, please. Be careful with your head. I will sit first. You feet in. Perfect. Thank you. Yeah. That's a comment. I'll give it before you.
Step on the second one. What? Okay.
Turn around. I'm going to check you first, okay? Just stay still. Anything you have that may pinch me? I have nothing else. Okay. I still gotta ask. No, that's okay. Okay. I still gotta ask regardless. Okay? Turn around. Face me. I'm gonna do the same to the front, okay? Just to make sure nothing drops. Thank you. You're welcome. Yes, ma'am. Just get air conditioning on this office.
Air condition doesn't go to the back because of the vent, because of the plastic.
Can we open this a little bit then?
Absolutely.
That's great, that's fine.
Okay. It'll be freezing in the jail, so you'll be glad you have it.
They're gonna take it. You're gonna get a gut ring.
Let's please get some water. Wait, you're gonna want more?
What?
I'm gonna want more. Thank you. Do you know how long we're gonna sit? Oh, how long we're going to sit here?
As soon as he comes back, he's going to take you from here to the orange room and then to the facility.
Oh, okay.
Yeah, whatever emissions request what he was missing, so he's going to enter that in the back.
Okay. So the next place is what? The warrant? What did you say?
Huh?
What did you say the next place was?
Well, see, what happened is the warrant that they had from you is from out of Leon County.
When did they issue a warrant?
So what happened is we have to take you to our warrants room for that information to get entered.
It makes sense that she's flying out of Miami because she's from South Florida, but she's got to ride in the jail bus thing all the way up here. That's like a 10-hour drive in a jail bus. Why are you in pain, Wiggles? I'm sorry. Oh, I'm sorry. I don't like when my friends are in pain.
But after that gets entered, before we can take you to the jail, to the local jail.
Okay, because I didn't know there was a warrant. How would I know that?
Well, we wouldn't have been able to take you if there wasn't something in place.
You knew there was something because you were running. So you knew there was something.
So aren't they supposed to inform? Aren't they supposed to inform me if there was a warrant?
Well, I don't know the details.
I don't either.
They had a warrant. The gentleman that you met earlier in the plainclothes.
Yes.
Right. They were supposed to inform you of whatever, and then because it's a county warrant, that's how we became involved.
Okay.
All right.
Yeah.
Here's something. Let me lock the door.
Just push my glasses up a little on my nose.
Absolutely. Like that.
Oh,
okay.
thank you.
Oh, you're welcome. The little that office right there on the corner. We get the door for you.
She's asking for all this water. I didn't know there was a warrant. And yeah, you did. That's what you received in the
Thank you. How you doing? Just have a seat over there. Just stay here. Just pick this up. We turn around a little bit this way, so always protocol that we need to, you know. Rules and regulations. Ready? Whatever. Take your time, no rush, cover your head. We're gonna go through that door over there. Can you show me a right with a 2K? Ready for him? Six zero 14. That's how it's used. Oh, you know why? Yeah. Yeah. That's why. Well, let's stand over there just in case it's raining. How you doing, boss? I don't know if I'm like that.
Donna Adelson and Cussy. What'd you think of that, folks, huh? How about that? Let's introduce our think tank. Joining us today, studio criminal defense. Come on now.
Did you see Harvey wipe his forehead saying, it's over?
Okay, I'm gonna, since some people came in late and that hearing was super short. Oh, why did I do that? We're going to watch the hearing again because it's super short and some people came in late and they missed it because it was so short. So we're going to do this again.
I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials.
And Sarah Catherine Dugan for the state.
Joshua Zoman and Jackie Fulford for Mrs. Adelson.
Good afternoon, Your Honor. John Morrow on behalf of the witness, Wendy Adelson, and my colleague Matthew Luca is with me as well.
Good afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor. No position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been two prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know, if we called her, she could rebut what has been said. It's not necessarily would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
Okay, so the state and the defense have both subpoenaed her. The state can give her immunity for anything she says. The defense cannot. So she is going to be a witness for the state. So she is going to be a witness against her own mother. She obviously doesn't want to be, but so she's going to be rude and hostile and short-tempered, just like she was in her brother's trial. However, they're going to give her immunity. So she can get up there and say what she wants and she's not going to get in trouble. However, if the subpoena for the defense stands, they can ask her whatever they want and she would have to answer it and then she could get in trouble. But this way, since the judge quashed the subpoena, they can only ask her questions that were raised, that are related to questions raised on direct from the prosecutor. But if they do happen to get into an area with her that would incriminate her, she will be allowed to take the fifth, to claim the Fifth Amendment. So if, like she said, let's say something comes up and they know it's not true or whatever, but they know that Wendy knows the truth, they cannot call her to get up there and say that's not correct because the judge quashed the subpoena, because that's what Wendy made a motion and the judge granted it. But she's still going to be a witness in the trial.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lawyer. I'm going to allow Ms. Fulford.
I'm sorry. I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
So the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lawyer, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanois trial. It was also decided upon by the first DCA in July 2025 when the DCA ruled that the procedure used by Judge Wheeler was entirely correct and the subpoena in that case was quashed. It was the same issue that the defense raised where they wanted to cross-examine my client pursuant to a defense subpoena which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena and quashing the subpoena Ms. McBanaway did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further,
We don't have tag team motions. Who's going to finish the argument?
Just a moment, Your Honor.
That is so stupid. She started the whole thing. Why did he even get to speak at all?
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanaway would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking the juries to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor. The statement by counsel is patently false. This was raised that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA, and we respectfully request that Your Honor follow that ruling here. There is simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
All right, having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time, but I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laura, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this.
Okay, that was that. Let me see. What else? The one 8 days ago was an hour and 12 minutes. There's one 10 days ago that was an hour and 22 minutes. This one was 10 days ago. It's in 57 minutes. Let's see. That's a month ago. It was 16 minutes. 5 months ago, that one was 3 hours. Case management 2 months ago was an hour and 17 minutes. 11 months ago, motion hearing was 2 hours and 11 minutes. 3 months ago was 36. Dang it. I'm gonna have to put all these in order.
Case number 2023 CF 3226, State versus Donna Adelson. All counsel of record may make their appearances.
Matriarch Appleman for the state, Your Honor.
Okay, this was 11 months ago.
Before I get off Len and McNair, Ms. Dugan, I neglected to ask you if you had anything to add on behalf of the state. Bailiffs, if you please could get back to defense counsel. Do you have anything to add, Ms. Dugan? Very well. We'll continue with Ms. Adelson at this time. I want to go through all the motions that we are. Oh, let me turn.
These guys might be, I think, I'm not positive. These might be the ones that were her son's her son's attorneys. Because I know at first she wanted to use the same attorneys that her son used, and they said that was a conflict of interest, and she waived all conflict, whatever it's called. But then I think now she has different attorneys. I don't know.
And on the Zoom as well before we get rolling.
Thank you, Judge.
The court taking that issue up today, because I think the court's going to need information in the as well. But the motion was filed based on the receipt after the deadline, the discovery deadline, if you will, for in Mr. Corbett's presentation, which is 300 and something odd pages. Mr. Ashbaum, there was some back and forth in terms of when we would get it and that sort of thing. We needed it before Sergeant Corbett's deposition, which was taken with...
Talking to a microphone.
Yes, sir.
It's a standing order of the day. Everyone who speaks, speaking to a microphone.
His deposition, Sergeant Corbett's deposition, was taken in the midst of last week, and so the motion was filed immediately on the heels of that once we learned the information that was associated with his testimony and presentation.
Very well. As to that motion, I've not had an adequate opportunity to review it. I assume the state needs some time to prepare this as well.
I'm happy for it to be heard whenever it's convenient for the court, Judge.
So we can stay on our existing timeline of meeting the jury selection on the 17th. For now, let's tentatively schedule this for September 6th. Please consult with Lynn as to a particular time and courtroom. If I'm going to need additional time before we get to the 6th, I'll let you all know. Right? And also, the other motion that we will hear today is the defendant's motion to preclude travel as consciousness of guilt.
Judge, for the motion that was filed this week by the defense, I did go ahead and put that draft of the presentation that they received on Bosch Track for you, 329 page one. I have sent one or two things since then, I believe, to the defense, and I guess they'll just let us know if they have an issue with that. Okay.
Thank you. One other matter that I want to address as well before we get to the argument of the motions. Mrs. Adelson, previously I have addressed with you the fact that you are waiving any conflicts as it relates to the representation of Mr. Rauschbaum. Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand. Do you swear or affirm the testimony you're going to give will be the truth?
Yes.
You can lower your hand. Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case, or a similar case, in this matter?
Yes.
Do you understand that he has a duty to hold in confidence certain aspects of that representation?
I understand.
Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial?
Yes.
As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way?
Yes.
Have you had an ability to consult with other counsel as to whether you wish to have a conflict-free counsel?
I'm aware of that, yes.
And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this?
Yes.
Thank you. You may be seated. And again, so it's clear why I'm doing this, ma'am. At this stage, as we move closer to trial, things are going to occur rapidly, including rulings on the motions that you filed, rulings on the state's motion, how this is going to affect the evidence, and how this will ultimately affect your trials. At any point, if you decide that you are no longer willing to waive this conflict concerning the representation, that's something that I'm going to need to address. Do you understand this?
I do.
If defense counsel as well becomes aware before the next hearing that the conflict is no longer waived, please bring this to the court's attention.
Yes, Your Honor.
All right. Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay. Mr. Morris, Mr. Rauschbaum, whoever is arguing this on behalf of the state, I'll allow you to proceed at this time.
Judge, may I approach the lecture?
You may.
I got it right, thank you.
A+ for use of grammar. Go ahead, sir.
So, Judge, to go into too much detail other than what's said, I don't want to. There are two components that need to be shown. You need to show prejudice. We need to show a delay, first of all. That's clear. I think that's clear on the facts. The murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial, the first trial, Catherine McVandel and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine Magbanua, Sigfredo Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I ask the question is because the motion makes a reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of your motion, correct?
I mean, yeah, look, she could have been charged any time after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, to be clear, this is not a statute of limitation. There is no statute of limitation.
There is none.
So we agree with that. But she could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear in 2024. So the only new evidence since then is her trying to get on the airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016, right? And they certainly had it in 2019.
So 9 years is 9 years from, I guess, the murder, right? But if you're looking at it in any component, you're looking at what would fit under Florida law, under the 11th Circuit law, certainly a time delay, okay? So when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of the main components of their case are call patterns, and I use the word patterns lightly, because in order to show a pattern, you need a length of time to show a pattern. So when they got call records, I believe, starting in May of 2014 through July of 2014. So they got a very short period of time. Because she wasn't charged in a timely fashion, call records showing that there is no pattern, that this is exactly what would have happened earlier, these pattern calls, existed back then, but they haven't existed for years.
What was the retention policy for the phone service provider?
I believe it was 3.5 to 4 years. So that would take you back to 2019, give or take. And so we're able to not fully defend that point because the records don't exist anymore. That's prejudice. The second component are some text messages. So they have text messages where they claim it shows that she is outside of Charlie Adelson's house. We have to defend that. Is there one main piece of evidence? This is a premeditated crime they're charged with. Is there one piece of evidence after the murder? There's very little piece of evidence after the murder other than that and the wires. So the way to defend that is through SunPass records. Those SunPass records don't exist anymore. Now,
what is the record retention on the Sun bill?
3.5 years is what we're told. And that's what Agent Corbett testified to at the last trial. So, Judge, it's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves. Now, the second component is a bad faith component. I think the prejudice component is clearly established here. The bad faith component, it's important to know that under bad faith, you do not need to show a sinister motive. The law in this court is clear, right? United States v. Foxman, 87 F. 3rd at 1223, says that bad faith in this context does not require a subjective sinister motive on the part of the prosecution. That's important, okay? We don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip, and they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time, they didn't flip. And so they waited, and because of that, we were put in a position where these records no longer exist. Now, Judge, we do argue in the alternative in this motion. And what we argue is if the court is not willing to dismiss the case, they should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all call records, that they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists, and we don't have the ability to show it. With regards to the text message, we think it should be excluded. The SunPass records would clearly show whether Mrs. Adelson was at the house or not at the house. It would definitively show. Well, let me tell you why. Because you would see, what SunPass records show back then, as they did now, is they show entry onto a turnpike.
Correct.
And so you would be able to see when she entered the turnpike.
Let me stop you there.
Yeah.
Are there not methods to travel and avoid the turnpike points? But where it might not be as direct, it might not be as easy, where if you enter the turnpike here, you have an easier point of access to drive, but ultimately, could she have reached Mr. Adelson's home and avoided the SunPass altogether?
Their records show she did enter the turnpike. Their own witness shows that she entered the turnpike because he's got, on his many charts where he guesses, he's got her on the turnpike through a cell tower. So you don't have to guess that she entered the turnpike. You know exactly that she did enter the turnpike. Their own records show that she entered the turnpike at what's called the Dolphin Expressway. Okay? So you go take 95, and you get on the turnpike at the Dolphin Expressway. That's where Dolphin Stadium is. You would, first of all, see on the SunPass the entrance there. And their records show that she's on that. Their cell tower records show that. Okay? Their cell tower records show also time frames on that same turnpike. Shows on their map, on their dots. They show her on the turnpike. What it can't show is if she got off the turnpike. It may not have shown her get off the turnpike, but it would have shown her get back on. So in other words, if they're correct, and she had gone to Charlie Adelson's house, which she didn't, but if they're correct, at some point she would have had to exit the turnpike. Okay? It wouldn't have shown her exiting the turnpike because when you exit the turnpike, it doesn't show you exiting. But they have her at a certain point in time back on the turnpike. They would have known when she got back on the turnpike and where. And that would have showed whether she was at his house or not. Definitively it would have showed it. We wouldn't have to guess about it. It's just how the turnpike, it's just how the Sun Pass records work.
You got to get off the turnpike to get back on. So if there's a record of you getting on it going one way, there's a record of you getting on it coming back the other way.
It shows when you enter, and then it shows parts at the turnpike. So they're using a witness to make guesses. They have these beautiful charts where they have her pinpoint, and then they have Charlie Adelson's house, and they show that it could take from this time to this time, extra time, but they have no idea when she got off, where she got off, why she got off, and they would know for certain, 100%, we would be able to show for certain, 100%, if we had those records, whether she was at his house or not.
Excluding for one moment a future argument about Sergeant Corbett, why it is not right topics for cross-examination.
Judge, I mean, clearly if they're allowed in, they're right topics for cross-examination, but you have to do a balancing test. This is the premier piece of evidence in this case. It is the #1 piece of evidence in this case, outside your house. Because it is the only piece of evidence in this case, other than the wires, that ties Mrs. Adelson to anything after the murder. It is the only piece of evidence. We have the wires speak for themselves. We have the checks that she wrote, we're not going to argue that she didn't write the checks. This is the only piece of evidence. And you're using conjecture to get it in, where if they had charged this case in a timely fashion, we would be able to show definitively she wasn't there. That's not our fault.
All right, let's go back to the U.S. Supreme Court case that is the genesis of this argument, Velasco. I believe Justice Marshall goes through the role of the prosecutor and their duties, and also discusses how the prosecutor has an affirmative duty not to charge someone before they have probable cause to thoroughly investigate the case, and also not to clog the court system with cases they cannot prove. What is your response ultimately to this discussion as it relates to this case?
I think it's a very fair question. I think what you have to do is you have to then look at what has changed. So in other words, in doing that, that can't always be their answer, right? They can't just have a blanket answer.
Right.
They have to be held accountable as to, okay, what has changed, right? And the reality is, when you look at this case and you see what is going to be presented, you have the exhibit list.
It doesn't show where you got off, but it shows the last toll you go through. Because it takes a picture. Every toll part that you go through where you have to, because they have to know what to charge you. I like the way it is now, where they changed it. They just take a picture, and then when you get home, you get a bill. Because I don't have a Sun Pass thing, because I don't use it that much. So when we do use it, we just drive, and we get a bill like a week later in the mail. But it takes, when you get on, it takes a picture, knows where you get on, and then like every time there's a place like where it changes, like where you pay or whatever, it takes a picture, and then it takes a picture at the last toll where you, right before you get off. So it kind of does tell where you got off, and then when you get back on to go back the other way, it starts tracking your car's movement again. So I don't understand why he's arguing that it doesn't know where she got off the interstate, because off the turnpike, because yeah, it does. Not maybe exact pinpoint, but it's got the last toll she went through.
Look at the exhibit list for this case, and you compare it to the exhibit list in 2019, it is essentially the same exhibit list. 2019, the first trial. I'm not even talking about Charlie Adelson's trial. It is essentially the same exact exhibit list. Their exhibit list contains, essentially, against Mrs. Adelson, emails that they had back then, wires that they had back then, checks that they had back then. That's essentially their case against her. Okay? So the reality is, you're right. They should not charge people that they don't have probable cause for. But that can't always be their answer. They have to be held to ask, well, what has changed? We asked a similar question in the last trial, and their answer was dolce vita. Okay, but dolce vita doesn't apply to Mrs. Adelson. She wasn't there, right? Everything that they had in 2000, and by the way, they had dolce vita, they just didn't have a clear version of it. The reality is, you're going to see that 95%, probably more, of this case that we're about to hear is the same exact case as it was in 2019. Almost the same witnesses. Almost the same evidence. It's the same case.
Any further argument?
No, Your Honor.
Ms. Dugan and Ms. Kappelman.
Thank you, Judge. So as the defense's motion states, the test here is going to be whether substantial prejudice is caused, not just prejudice, to the defendant's right to a fair trial, and was it the product of bad faith so that dismissal is required. The two pieces of evidence that they talk about in their motion are the phone records and Sun Pass So I wanted to quickly go through each. For phone records, he says, well, there are call patterns between the parties that occur on major events during the planning of this murder that the state presents. But every time we present this evidence, we also concede and present the fact that the people in this case, they all have relationships outside of any planning for this murder. Their boyfriend, girlfriend, their parent, child, they have children together. Those people in those relationships talk every day. That's normal and that's to be expected. And all these people do talk every day during the time that we have these phone records. Every time we've tried this case, the defense picks a random day. This is every trial we've had since 2019, I guess. Every defense attorney picks a random day that summer and shows that, hey, there's also calls between these folks on these other days where there's not a trip to Tallahassee or some other big event in the planning of this murder to show exactly that. They've done that every time through cross-examination, and they do that without having prior records prior to May of 2014. So there's no substantial prejudice to the defendant, and there's no bad faith here. Law enforcement subbed records beginning in May of 2014 because they're trying to get records from around the time the shooting occurred in July of 2014, so a little bit before. Then also we have records after. We have records leading up to 2016, where there was no murder being planned at that time, and obviously all of the parties in this case, as we established in the case, are still in contact. They're still talking because they all have this pre-existing relationship.
Before you continue, is there a reason the records that are at issue in this motion were never pursued?
Because those are the times around the June and July trips where there was the attempt to kill and the murder of Dan Markel. We have messages between them going back before that time, but we believed, or law enforcement believed at the time that they subpoenaed those records, that was the most relevant time to the information in this case. That would be relevant in this case.
Were any further subpoenas as to SunPass or phone followed up on once the state believed it did have probable cause against Mrs. Adelson?
I believe that after, so getting to the SunPass records, the SunPass records, we did, I think, try to get late last year once it came to the light. Can I address the SunPass records and I'll let you know kind of what it was? Okay. All right, going back to the phone records, though, this is not substantial prejudice, and it's not a situation, though, where the state purposefully did not indict Ms. Adelson until she could not get these phone records anymore. So there's no bad faith in this case. It's not a situation where we purposely didn't indict her so she couldn't get that. Moving on to the SunPass records, first of all, there's no substantial prejudice that these records would be exculpatory. As the court pointed out, we don't know if there was a way she could have avoided that. We don't know if the exit or entrance even had a transponder in 2014. In fact, given that the defendant texted Charlie Adelson outside your house, and there was a witness at trial, Catherine McVanois, who said that the defendant had been at the house that night right before she arrived, we believe the SunPass records could very well be inculpatory. And there's no bad faith here because we would actually like the SunPass records too. We did, as the court asked, we had Jason Newland make a call to try to see if we could get the SunPass records. I believe it was last fall in 2023, but we also...
Is this all the evidence they have that she was at his house, his SunPass records?
Learned that they don't have them anymore this far late in the game, but the bad faith portion of this is only satisfied when the government makes a judgment about how to proceed with litigation to gain advantage over the defendant, and as a result, the indictment is delayed. The reason we didn't try to get the SunPass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine McVanois offered that information in 2023, leading up to Charlie's trial and at Charlie Adelson's trial. Catherine McVanois mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before you continue, was this new information learned either through the proffer or trial preparation that had never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which was all in 2023. The trial being Charlie Adelson's trial in fall of 2023.
Well, Charlie is in Tallahassee. I saw that today on somebody's thumbnail. Charlie is in Tallahassee. I don't know which side he's testifying for. Wendy's testifying against her mom, just like she testified against her brother. I bet you Wendy was there that night too. I really wonder. So they didn't arrest Donna until after Charlie's trial was all over and done with. And Wendy testified in that one. And now I'm wondering if after this trial is all over and done with, if then they're going to arrest Wendy. Because, yeah, she's got immunity. But if I recall correctly, I think somebody on Court TV or Law and Crime said something about it's not blanket immunity. She can still be arrested for the crime itself. The things that she's testifying about are not things that give her immunity if she actually was part of the crime. But I don't know all that much about this case to know if that is actually the way the immunity was granted. But he's going to testify because he's in He is in Tallahassee. Did he get the death penalty? Because if he did, he was in Stark, which is not far from where I live.
Obviously, Donna Adelson's phone locations, right, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from, and that was this relevant to the money drop, until Catherine McManus said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was damp. She believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived, and that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, and we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside her house. But this wasn't a situation where we waited to indict Donna Adelson until SunPass records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had been a deliberate act to gain a technical advantage, and that's not what we have here. I'd also point out, Dan Rashbaum has said that he was retained in this case by Donna Adelson in 2016. And every trial that we've ever had has been on YouTube, if anybody wants to see it, and they could have, if they believe that these SunPass records and phone records were so exonerating and obviously needed, those could have been requested prior to when they would no longer have been able to have been received.
Can the defendant, absent an active case of a subpoena of this nature?
The defense said in the last trial that he tried to get the SunPass records and he wasn't able to, before we had even thought to try to get them. I'm not sure when he tried to do that. Another thing here is that if the court denies this motion, I think at that time it would become right, the state would ask that the defense not be able to argue in opening or closings or testify in their own questions that, hey, because the defendant wasn't indicted until 2023, that means law enforcement or the state attorney's office didn't believe they had enough evidence. What anyone in law enforcement or state attorney's office thinks in this case is not relevant. Given that, we believe that, obviously the dates that law enforcement received evidence, the dates that, suspects were tried or convicted, those things are all fair game and can be pointed out by the defense, but not the argument that this delay was because the state attorney's office or law enforcement didn't believe there was enough evidence to convict.
So to summarize in a nutshell, the state did not even understand what it had in the way of a text message until Catherine McManus was brought her.
That Catherine McManus' information that she provided to the state really made us zero in on that and realize that money could have been exchanged at that time by Donna Adelson to Charlie Adelson. And so, obviously, we always knew that they were traveling up to Tallahassee that night, the Harvey and Donna Adelson were.
After the murder took
Yes,
place.
sir, but Catherine McManus' information that we learned after her trial, when she began to cooperate and leading up to Charlie Adelson's trial, is what made us zero in on that.
Very well, thank you. Brief response, and then we'll move on to the other motions.
Sure. Judge, I'll do the factual point first. I was retained to represent Donna Adelson in the late summer of 2016. Okay, so I think it was the end of July, beginning of August 2016, I was retained to represent Donna Adelson. The first trial happened in 2019. When that trial happened, we tried to get SunPass records. We did.
Wait a minute.
We couldn't, because we weren't an active party. We didn't have any subpoena.
Why were they hired to represent her in 2016? Charlie's trial was 2019, right? When was Dan Markel killed? See, this is why I don't know enough information. This is why. No, that didn't come out right. This is why I need to know more information. Yeah, exactly. To a country that didn't have an extradition treaty with the U.S. Yeah. Consciousness of guilt. I need to watch some documentaries about this thing, because if he was retained in 2016 for her, and then he became Charlie's for his trial, and then she wanted them back for hers. Oh, man. Why did she need one in 2016?
Were you stonewalled by SunPass?
Yeah, exactly. Okay? When we tried to get SunPass records again was when Charles Adelson was indicted in the case. Then we were able to subpoena and try to get SunPass records. We were unable to do so because they didn't exist. So let me be clear on that. Okay? All right? The first time we were able to attempt to get SunPass records, they no longer existed. Okay? Now, with regards to them, she makes a point that every counsel has picked a prior date. Let me tell you what happens. We did pick a prior date, but our universe for picking a prior date is like this date, right? And you'll recall at the last trial what happened with the prior date we picked. Right? There are named prior dates. They found a court filing on that prior date. By the way, the court filing wasn't anywhere near the time of the calls, but they found a court filing on that prior date, and they made a big showing that this is another event, right? The reality is we want to find dates in 2013, in 2012, in January of 2014, in February of 2014. None of those existed because what they did is they got records only for a 4-month period of time. And any date that
As to that point, and I understand what you're getting at, but don't defense counsel in all manner of cases all the time say the subpoena was too wide, he passed too far. Meaning, the murder, what led before, what led after, there's really not a lot of argument as to the relevance. But if the state is seeking records of your client, or hypothetically any defendant, going back years in advance, are they really permitted to do that?
They don't need to go back years in advance, but they're presenting evidence in this case. Let me make 2 points to that. First of all, they got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back, number one. Number two, they're putting emails in this case back from 2012. Why not go at least back to 2012 or at least back to 2013? They just cherry picked a 4-month period. And by the way, the records she talks about that come on later, they're related to the bump. They're not related to anything else, they're related to the bump. So yeah, they created an activity, and of course, that's going to create another pattern, right? The reality is, it's unfair because they're making a pattern argument that doesn't, if it was a science experiment, it'd be a false experiment. Their sample size is too small. And we can't counter it because the records don't exist. And we don't need to show that they did it we don't need to show that they indicted her after the records existed. We're not claiming that that's what they did. They made other strategic decisions to delay her indictment. And those other strategic decisions had this consequence. And because of that, if you don't dismiss the indictment, you should not allow these records to come into evidence.
Do you have any response to the effect of the proffer as it relates to the messages? Ms. McDonald's proffer, which was taken last year.
Of course, they had the message well before then. They had the outside your house message well before then. It's not, listen, when I saw it in discovery, which was before a proffer, I knew exactly what they were going to argue. It's very clear. You didn't need her crazy argument to know what they were going to argue.
Well, let's look at this from the aspect of bad faith. Is it possible in a voluminous case file to not know what this one piece of paper actually means until a later date?
It is possible, but you have three, because there's been 3 prosecutors in this case, very fine prosecutors who have tried this case going into that case 2 times. So very unlikely. Very, very unlikely. That's what I would say. Possible? Yeah, anything's possible. But it's not that hard of a message to figure out. You have one of the key suspects in the case who you've got other records for, communicating with another key suspect in the case, who, by the way, in 2019, their theory was the same, that it was a murder for hire done by these 2 individuals. You have those, and you don't have many text messages between the 2. And you have one, you only have like 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up, outside your house, 10 minutes is the response, was not an important text message. I mean, if you believe that, I don't know, Judge. That seems a little, I'm skeptical of that.
Did they have the benefit, though, of the proffer until Ms. McDonald gave it?
They didn't have the benefit of the proffer, but you should listen to that proffer, because she doesn't talk about the outside the house message. And by the way, in that proffer, she doesn't even really talk about what they say she talks about. She did it on the stand, but she didn't do it in the proffer. That's not my memory of the proffer. She didn't say in the proffer that I don't believe that they had just left the house. That's what she said on the stand. They'd already put in the outside, they'd already marked that as an exhibit. So Judge, again, the standard is lower than what they're saying. Right? It's a bad faith standard, but it doesn't need to show that they purposely waited until after the SunPass records didn't exist anymore. We're not alleging that. We don't think that that's what they did. We think they made other choices that then made it. Look, at the end of the day, Judge, what it also is you get to do a balancing test. And it's a fairness argument.
Belle just fell over. Instead of just laying down, she just went boop. And then just started rolling around on the floor. Yeah, I'm going to have to. So he's saying she said it on the stand. Is he talking about Wendy or is he talking about Donna? Did Donna testify at Charlie's trial? Now I'm thinking I need to watch Charlie's trial. I know that the jury is going to get all the information that they need. Therefore, so will we. But now I feel like I've missed something. Like I've come in the middle of the story.
No, aside from everything else, it's a fairness argument.
It's clear that that's rooted in due process.
Yeah, it's a fairness argument.
I'm going to reserve ruling as to this. Also, prior to making a ruling, I'm going to review the trial testimony of Ms. McDonald concerning the outside your house text message, as I believe it does give context to what is being argued in the motion by both parties. Right, let's move on to the defendant's motion to hold trial in courtroom 3B. Mr. Morris?
Thank you, Judge. We've had a little bit of discussion about this previously. There are a couple of practical reasons. you're going to be the best judge of what occurred during Charlie Adelson's trial and the interactions with jury and gallery. Essentially, this motion seeks a prophylactic measure against that. You're great at controlling your courtroom and being able to interact with the audience and gallery.
But you still want a different courtroom.
Yeah.
Are you trying to butter the judge?
Don't butter me up. Get to the point.
Oh.
Fair enough. Judge, where we sit at council table there, the prosecutor's table obstructs the view of jurors 1, 2, 8, and 9. There's no ability for Ms. Adelson to view those jurors. There's no ability for the jurors to view Ms. Adelson or defense counsel. And of course, that's an important facet. Defense counsel sits here, displays here. Examining a witness, you park at the prosecutor's table, of course. Disconcertingly, in the last case, there were circumstances where communications between counsel and the defendant are posted on the internet before the lawyer can even get back to their hotel. And so it's been interesting to read the, media response. This isn't a circumstance of trying to curtail the media's ability to gain access. It's a function of trying to facilitate there are fewer opportunities for problems to arise. It's a practical consideration, and of course all of this is in your discretion.
Well, I was going to say, in researching your motion, I did not come across a fundamental statutory or procedural right to be tried in a particular courtroom that you have one to argue today.
No, I do not. It's a due process argument and an argument of prophylactic measures to protect against, and then the last component, which I've tried many cases in the courtroom, multi-co-defendant cases in the courtroom. All of them are different. The acoustics in this room are rough sometimes, but from the number of inmates.
I don't get it. Like, in a hospital, the nurses' stations are built for what their function is. Like, I can't think of any specific examples now, but, well, like where you sit to chart, there's a knee hole underneath the desk, and there's cabinets where you store stuff, not where you're going to sit, for instance. That's just an explanation of, like, it's made for how the function works. They need to do the same thing with courtrooms. I don't know why they don't do that. The acoustics need to work right. The tech, there needs to be places for tech. And as tech goes more advanced, they need to upgrade the courtrooms to the more advanced techs. They need to have it where everybody can see everybody else. Why don't they upgrade? I don't get it. And another thing I don't know, how many jurors gets picked? Because in Florida, we only do 6, but I don't know about murder cases. I'm going to have to Google that. Judy. Oh, I think she might be watching. Yeah, they need to upgrade them. They do. I think Judy might be watching the Ali sentencing. I'll Google it. Because I think sometimes we do have 12 jurors. It's 6 for murder trials too, Ken? Man. That just doesn't seem like enough people. That just doesn't seem like enough people.
That we potentially have testifying in the case and the movements of people.
Yes.
It's not my challenge. It's the bailiff's challenge. There are security issues, and I know there's difficulty here. Courtroom 3B is smaller and more compact. I know that there's someone has mentioned that there are technological concerns of it being antiquated. No better time for us to ask court admin for an upgrade. We've got time to be able to put a machine in that works appropriately.
I swear, I think Florida's the only one that only does 6. But I thought we did 12 for some cases. That just does not seem like enough people to send somebody to prison for the rest of their life. What about for death penalty cases? Is that 12? The penalty fate? No, that would be weird, though. If, like, 6 people sat on the jury for the murder case, and then you would have to sit more people for the penalty phase, so that has to be 6, too. That is so weird to me that it's only 6.
It's really a functionality and a practicality argument to make sure that we best protect Ms. Adelson from things that we've seen occur previously.
Very well. What you raised about counsel table, when we do have co-defendant trials in this room, a second table is added. There's the defense's preference to ultimately have what would be considered as the co-defendant's table and face the jury for the duration of the trial.
I think we're, irrespective of which courtroom, I think that we would need a second table anyways. We have one additional person sitting at counsel table with us during the trial, so there would be 4. So we'd have the traditional L, if you will, from whether it be in 3B or here. It's a little bit more difficult here because of the configuration to be able to put that many people.
Thank you, Ken.
To answer your question, yes, we'd like to be facing the jury, but 3B,
okay.
I guess.
All right.
Response from the state as to this motion.
Thank you. I knew that something was 12. I just didn't know what it was. Thank you so much. You guys are so good to me.
Yes, sir. Yesterday, a letter was sent by the Markel family stating their reasons they wanted to remain in 3G. Did the court receive that?
I was able to review it. There were also some other letters that I received, either from concerned parties that were forwarded, I believe the state and defense as well. Did everyone receive the letters of the concerned parties?
Yes, sir.
You may continue.
Aside from those letters, just from the prosecution's perspective, the primary reason for us asking that it remain in 3G is just from a practicality standpoint when presenting the case. You know, in 3G, we have the big screen overhead, we have the multiple screens in the jury box for the individual jurors, we have a screen, an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector that, from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes just actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and I know
You know I hate that television.
Right, it's a pain. And so, being in 3G isn't just some visual evidence to be shown. In this case, we have surveillance video, cell phone records, maps, text, emails, financial records with graphs and charts and electronic wire transcripts and other visual demonstratives that I think will be much easier for the jury to see and understand if the trial is in 3G. In the defense motion, they bring up, the inability to see the box that the judges already, or as the court's already addressed. They also bring up the lectern placement isn't optimal. I routinely will move the lectern with the microphone over to the projector so that I can operate the projector, or have my laptop up here on the lectern so that I can use my laptop and have it on the big screen so that I'm still at the lectern and not, and can move it about. And I think that should solve their problem, the ability to move this lectern around. Finally, I just want to point out that, the defense is concerned about juror distraction. However, in 3B, the jury box is extremely close to the gallery. So I think that there's a risk for distraction there as well. And I think that the court in the last trial, through instructions to the jury and through, making sure there was no cell phones used, was able to remedy that.
Very well. Prepared to rule on this issue today. I believe as the final jury instructions make clear, the jury will be instructed that they are to decide this matter based on the nature and quality of the evidence presented. The court is going to take all means necessary to avoid there being any distractions from persons present, sitting in the gallery, or attempting to improperly influence the jury in some manner. The examples that were cited by the defense, the court is not taking lightly. At the same time, the court does not have a way to ultimately prevent what is being complained of in the motion from happening in any courtroom. I am going to be very diligent and also very thorough in deployment of bailiffs as it results in this matter. The court also will take all suggestion from the defense as it relates to the placement of the table, so the defendant can be clearly seen by the jurors throughout the trial. As to the placement of seating on the defense side, ultimately, any observers or onlookers in the gallery are going to be placed at least 2 or 3 pews behind the defense, so that way there can be no attempts to either photograph or record the defense's interactions with each other, with Mrs. Adelson, or attempt to get any snippets of papers or other matters. Concerning the media and also any onlookers, I'm really not going to get into why people wish to come, if they have a legitimate interest or if it's just a curiosity for them. The Constitution provides that the courtroom will be open, unless there is a statutory or otherwise basis for closing the courtroom or excluding persons. The courtroom is considered open. However, the conduct of those persons, the court will closely monitor. Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around. The defendant's motion to move the trial to courtroom 3B is denied, and this is also for practical purposes as well. Courtroom 3G is the most recently renovated courtroom in the Leon County Courthouse. It has technology options that are unavailable in the other courtrooms, and it is also best capable of accommodating the needs of this trial itself. If the state can prepare an order or defense as to the denial. Let's move on to the defendant's motion to suppress wiretap interceptions.
Judge, I'm definitely not going to belabor this motion. It is the same exact motion that was filed in the last trial. It was denied in the last trial. The only difference in this motion is we have a section where it shows that Ms. Adelson has standing to make this motion. So, Judge, I'm just going to rest on the papers, unless you want me to answer questions.
The state is contesting the standing of the defendant to raise this issue, correct?
Correct, Your Honor.
Does the state have an additional argument to make concerning those?
Judge, I do have a couple things I think I should put on the record so we're not relying on your previous ruling in this case.
Go ahead. Well, as to certain findings or conclusions of law as to my review of Judge Hankinson's authorization those to a certain extent I will be relying on, but I'll allow you to continue to make your argument.
Yes, sir. I just want to put a couple things on the record regarding the standard for, it's alleged in the motion that necessity is a standard, and truly that's not the case pursuant to Phillips v. State 346 Southern 3rd 1252. Exhaustion and the objective of the criminal investigation are the standard, and in this case, we have met that standard by showing that other investigative efforts have tried and failed, or are too dangerous, or that this wiretap in this case was the most reasonable investigative technique under the circumstances. Regarding the objectives of the conspiracy in this case, the objectives of the wire in this case, it was to reveal the identity of the conspirators and their role in the conspiracy, so the structure of the conspiracy, and that's permissible under McGuire v. State 307 Federal 3rd 1192, that's a 2002 case. So here again, we're trying to identify the persons involved and gather sufficient reliable evidence to prove beyond a reasonable doubt what their roles are, what's the hierarchy of the conspiracy, is there any additional physical evidence that can be gleaned in this case, any information regarding monies or assets or other things of value. Regarding the staleness issue that's raised in the motion, I did want to point out a couple things. We note that the issue of staleness cannot be solved by a simple application of numbers of days without consideration for the overall particular circumstances presented in this case. Here, the circumstances of this investigation required efforts that involved a lot of record gathering and waiting for records and receiving records and analyzing them before we got to the point where we had reached exhaustion and were looking to seek a wiretap. The state's subpoena served on 12/14 of 15 requested a bunch of records between 14 and 15. Those were received in 16, including this defendant's checking account. We then subpoenaed a bunch of different Adelson accounts, that, including the one that the checks came from, and those were not received until 3/1 of 16. So, that accounts for timing. And there's a case that talks about, did I get it for you? Delay being appropriate in conspiracy cases, or more leeway being given in conspiracy cases, because of the nature of the investigation. It's going to take more time. And I think that it is, State v. McGuire, and Judge, that's it's U.S. v. McGuire, 307 Federal 3rd 1192, and that's a 2002 case, which I already cited. Sorry to do that twice. But that case specifically talks about the government being entitled to more leeway in its investigative methods when it's pursuing a conspiracy, as it acknowledges that's a different type of case, a different type of investigation. Lastly, Judge, I just want to touch on the issue of fresh evidence. As mentioned in the application for the wiretap, law enforcement anticipated the use of an undercover operative in conjunction with this wire, because in doing so would produce the fresh results that chatter on the wire. And fresh new evidence among these co-conspirators. The chatter that occurred between them to handle the blackmailer was brand new communication that could only be intercepted using this wiretap. With this new evidence, the argument of stale probable cause becomes moot, because the new evidence was being created at the time that the wire was up and the communications were being intercepted. And there's a discussion of this fresh evidence and the importance of gathering fresh evidence, and in U.S. v. Maestas, M-A-E-S-T-A-S, 2016 Westlaw 9725188. So that was all I was going to put on the record, unless Your Honor had some questions for me or wanted me to put anything else.
No additional questions. As to the application for the wiretap, did the defense have any additional exhibits that were previously not provided during the Charlie Adelson motion hearing or for this motion?
No, Your Honor.
Very well. The court will file its written order in this matter. Let's move on from here.
Judge, can we just ask if those exhibits be incorporated in the record here?
Yes.
Thank you, Your Honor.
All right, let's move on next to the defendant's motion to use a jury questionnaire.
Judge, the law says that it's discretionary. I think Judge Neff is doing one this week or this coming week, if I'm not mistaken.
Homicide?
Yes, sir. I saw some email traffic from Ms. Gaston with respect to it. But the objective is for jurors to come in, not talk about, hey, what do you think that we're here for, and what's your opinion on what we're here for, and let's discuss the case. And if we're able to have them focus on the answers of the questionnaires and then submitted, the defense feels like we're miles ahead in terms of information gained, decreasing the possibility of tainting the venire or the pool, and being able to hone in quicker on issues. Now, all of the questions, Your Honor, may take exception to some of them. The state may take exception to some of them may need to be recrafted. It could be made shorter, but the overall goal is to see if we can get more information in the door before we have to start doing work with them.
All right. From the procedure that was used by both myself and Judge Wheeler, I believe also Judge Hankinson, is there a particular thing that you're pointing to that otherwise negatively affected getting a jury?
I think there were instances have been brought to my attention, and I think it became evident in Charlie Adelson's trial that the jurors had been downstairs once they got up here, and they had been downstairs, and that there was communication amongst them about the very thing that I was mentioning. Why are we here? What's your opinion on this?
They also did not remain.
I'm sorry?
They also did not remain.
Understood.
I'll put it this way, if you can't follow instructions at the outset, there's no reason to keep going with you.
Yeah.
If anyone that I find in that way,
You and I
we don't have to worry about them being on the jury, but go ahead.
Are there additional instances of problems? I don't think my answer is yes, there are additional problems. I think it's a circumstance to be able to make it better and make it work more efficiently.
Very well. Response?
The state objects to using the questionnaire. We think, we'd like to hear and see these jurors answering the questions that the court asked last time. Sometimes it's just as important to see how someone answers the questions and their body language and what they say, and how they say it, as it is to hear the words that they're saying. So we'd like to not have one for that reason. Also, we just don't believe that it would save as much time and be as efficient as the defense thinks it may be. I think we'd have to litigate, well, what does it look like? And both sides are going to want something different. And then we've got 5 or 6 pieces of paper for each juror that the juror then probably ends up getting asked about anyway. So the state would object to it for those reasons.
Very well. As to this motion, the court will rule on it now. The court is going to deny the motion, and again, looking at this on practical grounds, ultimately, there is going to be examination by the court on the issues of pretrial publicity and hardship to serve in a trial of this length. The ability to engage an individual denier with the entire denier that has been summoned will sufficiently accomplish the goals of the jury selection. Both parties will be able to follow up on the court's questions. Additionally, as well, as my memory serves from the Charlie Adelson jury selection, several individuals who either were going to be cause challenges or other issues were discovered, such as them seeking to gain admission to the jury, were thoroughly rooted out during the process. And that way, this will work the same for Mrs. Adelson as well. Anyone who is biased or anyone who is trying to gain access to the panel improperly, we are going to get to the bottom of it. The process has worked. I believe it will work again. All right, let's move on to the defendant's motion in limine. As to the first prong, testimony concerning pre-arrest silence, the motion indicates that the state is not opposing this. Does the state have any additional argument, or is the position changed?
No, sir.
Defendant's motion in limine is granted as to prong 1. As to prong 2, wealth evidence, you may make your argument.
Okay, Judge, as you may recall, the state intends to call Mary Hall as a summary witness. I say summary witness because in the past she's been an expert witness, but I don't think she's an expert. That's for another day. But as a summary witness to talk about wealth records. If you recall, they put in records showing the combined wealth of the Adelsons. They go through a bunch of accounts and they show what their combined wealth was. Judge, we think this is clear that under U.S. v. Bradley, that evidence of the defendant's wealth may be admissible, quote, when relevant to issues in the case, and that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. Okay? This is clearly coming in for that purpose. Their wealth has no bearing on the issue in this case of whether Mrs. Adelson participated in the premeditated murder.
Yes,
there is no dispute in this case. We will stipulate it to it that checks were paid out of the Adelson Institute.
That was going to be my first question.
It 100% does, because rich people think they are above the law and can buy anything they want. It absolutely does.
As to your general proposition, I would say you're correct on the law in the same way. The jury is not to consider that a defendant is indigent and hold that against them. It would equally apply to wealth. As it relates to the state's theory of the case, is there any relevant evidence of wealth that you're still disputing?
No. I mean, the argument in this case is that she paid for a murder, and that is not our dispute. I mean, we're disputing it was for a murder, but we're not disputing that she signed the checks. We're not disputing that the checks came from the Adelson Institute, and we're not disputing that $100,000 was paid to Catherine Magbanua on the night of July 18, 2014.
Exactly.
We're not disputing any of that. We're not disputing that they have the ability to pay the money. Either.
Was there other evidence as to transfers of vehicles or other property that has allegedly been given to Ms. Magbanua?
There's evidence of a car that was given to Ms. Magbanua that was in Harvey Adelson's name. We will not dispute that either. Again.
So again, it's just generally, these are wealthy people, not the specific matters that are being alleged a part of the conspiracy or payment for the conspiracy.
We're not disputing any of that. So why do they need to show a wealth of millions of dollars? You know, they spend a lot of time on it, millions upon millions of dollars. What is that relevant to? I don't think it survives 401. But if you go to 403, it certainly doesn't survive that.
Response, sir.
Judge, this is a murder for hire. The state's entitled to prove that this defendant had the means to make the payments that are alleged, to make the payoffs that are alleged, to buy the cars, property, etc., gifts, etc., that are alleged to have been received by the killers. And it's relevant to show that they have the ability to make the $1 million proposed bribe that preceded the death of Mr. Markel. It's important to show the means relative to the payoff. So they had this was a drop in the bucket, right? That's important, I think, for the jury to understand the motive and the means and how this was executed.
Very well. As to this particular point, it will be granted in part and denied in part. As to evidence which specifically demonstrates that either Mrs. Adelson or one of the other co-conspirators used assets to pay Catherine Banawan or other members of the conspiracy, the state is going to be permitted to demonstrate that evidence. As far as any general presentation, however, as to all assets of the defendant, that is where the line is going to be drawn. As to Mrs. Holt being examined on whether the defendant had adequate assets to otherwise participate in what would be called the $1 million bribe, or is alleged to be the $1 million bribe, the court will permit that. Again, just going into a general examination of all of their assets as to showing in some sort of way to create a wealth bias, the motion is granted in that aspect. If we need to get more specifically into which pieces will be used, we can do so. Are there questions as to the ruling?
May I have a moment to confirm?
Go ahead.
Judge, may I make something clear to you that might help? We're not going to dispute the $1 million offer. In fact, we're going to bring it out. So that won't be an issue.
Yeah, I don't think they can hamstring us by stipulating to things. We still have
You don't have to accept the stipulation. I believe this much is clear as a matter of trial practice.
Let me just confer with counsel about the financial evidence and see if there's any clarifications needed.
Go ahead.
They paid $1 million? Yes, they need to know that he has money to pay for it.
So am I correct, Your Honor, that if we're inquiring of the witness, Hull, about the time frame in which, say, the $1 million offer was being proposed, we would be permitted to ask the witness, what did you analyze, what did you look at, and did the defendant have the means to make that payment at that time? But we would not be permitted to say what was the bottom line in her bank account at that date.
Correct. That examination will be permitted. What would not be permitted is to say the defendant had $10 million at TD Bank on this date. I believe that's ultimately what the defense's motion goes to. Am I correct?
That's correct, Your Honor.
I think we understand your ruling, Judge.
Let's move on to number 3, hearsay testimony from Jeffrey LaCoste.
Okay, this one's a little bit more complicated.
Not as complicated as you think, but you may make your argument.
All right, so Judge, in the last trial, we filed a similar motion, and you ruled in our favor. You excluded the hearsay testimony as being just that, hearsay testimony, okay? And what proceeded to happen, as we all know, is the state then asked the question of this piece of evidence, of these statements, to Wendy Adelson. Wendy Adelson denied that she ever said these things, and then they were able to backdoor it in through impeachment, okay?
Well, I wouldn't consider it as a backdoor as much as, would you agree with me, there are often times when it comes to evidence, may not be admitted for one purpose, does not exclude its use in other ways.
I would agree with that statement, but I would disagree that it wasn't a backdoor. But nonetheless, that was that trial. This is different because the question to Wendy Adelson in the outset in that trial was about a statement that Charlie Adelson made. So it fit an exception to the hearsay rule, which was it was a statement of a party opponent. Okay? In this case, the statement, if they asked Wendy Adelson the question in the outset, it doesn't fit such an exception. It's not a statement of a party opponent. Asking Wendy Adelson what Charlie Adelson said is still hearsay because Donna Adelson is the party opponent. And it's not a statement in furtherance of the conspiracy because none of this had to do with any conspiracy statement in furtherance of the conspiracy to commit a murder. None of these statements are in furtherance of conspiracy. So what I'm trying to say, in short order, is number one, we assume you're going to rule the same way, that it was hearsay, and prevent it from coming in through Jeff LaCoste. And what we're also arguing is that it should come in through Wendy Adelson because that is also hearsay. It's hearsay because it doesn't fit an exception. That it would have in Charlie Adelson's trial. It doesn't fit any exception in this trial. And so we're asking that it not come in at all. Now, when you look at the statements, they're all a little bit different. Buying her a television was cheaper than a hitman, that Charlie Adelson actually looked into possibly hiring a hitman, and then that Charlie Adelson described a dinner as a celebration. That's even after the murder. So that's even, and that Charlie Adelson kept large amounts of cash in his home. Right? These are all statements that are hearsay. Right? They're hearsay if asked of Jeff LaCoste, and they're hearsay if asked of Wendy Adelson. And as a result, they shouldn't be allowed to be asked or admitted.
Response from state.
I disagree, Your Honor. I think these are statements against interest. These are statements.
I need to remove some people from the Zoom.
Yes, sir.
Go ahead.
And are in furtherance of the conspiracy, Your Honor. If Charlie is telling the main beneficiary of this murder that he's looked into hiring a hitman, that's in furtherance of the conspiracy. And how much it's going to cost, too, was part of the statement. That Charlie Adelson had, in fact, in the summer of 2013, begun looking into hiring a hitman to kill Dan Markel, and the cost was either going to be $15,000 or $50,000. One of the two, she said, as you will recall. How can that not be in furtherance of the conspiracy, right? If Wendy denies it, then it's textbook impeachment to call the person that she said it to indicate that she said it.
And that is your argument as to all four of the statements that are being highlighted.
Yes, Your Honor.
Well, I'll reserve ruling on this topic for now. I want to do some additional research as to statements in furtherance of the conspiracy. Let's move on to number 4, testimony from Wendy Adelson.
And Judge, with regards to number 4, the state's position may or may not have changed on some of these. I just want to let you know that at the outset. They let me know recently that their positions were possibly changing. So here we're trying to prevent certain statements, certain questions from being asked of Wendy Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial for first-degree murder. The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes had anything to do with Donna Adelson. We don't know how that could have anything to do, again, with this case. The third is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice a jury. And so under a standard of 403, they should not be allowed.
Sure. Well, also at one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes and the validity of. Is everyone clear on those?
Yes, Your Honor.
Go ahead, Ms. Kaufman.
I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendy Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate, and that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida, and I thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can't imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to the other two items, I think those go to the state's theory that this crime was done in order for Wendy to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right. As to that point, Ms. Kappelman, I understand the relocation and the divorce proceedings as it plays into the state's theory, but ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain grown decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant to the state's theory of murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father. Right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further evidence to this issue?
No, Your Honor.
Just one briefly.
Go ahead.
Wendy Adelson is not on trial. So, I mean, this may be a different topic if this were the trial of Wendy Adelson, but this is the trial of Donna Adelson. And what they're trying to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendy Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Your Honor, for any of these good things.
Very well. As to subprongs 3 and 4 of number 4 of the defendant's motion of lenity, I will grant that as to prongs 1 and 2, I will give additional consideration to the argument that's been made. I will reserve ruling as to those subprongs from now.
Thank you, Your Honor.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay, and it's certainly not in furtherance of a conspiracy. This is after his conviction. So we're only talking about, let me be clear, we're only talking about jailhouse recordings after Charlie Adelson is convicted. So there are recordings in this case that I believe the state intends to use, I don't know, where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. There's an exception to the hearsay. It's not hearsay, but Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy. And some of the statements are inflaming.
Are any of these in any way tied to this issue of travel as consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think there are statements where Charlie is talking about his trial, and Charlie is talking about why he believes he was convicted, and Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using, but Charlie's statements are not admissible.
Right, state response.
These are statements against interest that are made by Donna Adelson or are adopted by Donna Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter that you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think Your Honor will know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where
This is
Charlie
on the loan application.
Yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show, like, this is what's happening. It's a call where he's dropping off. She's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
That would probably be best before I rule on this.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction, as it relates at least to law enforcement and a defendant's interview, is your argument essentially this goes to the context of the call?
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well. I'll need to review these calls before I can actually make a ruling on, because as the defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problems and we have relevance problems. Ultimately, I assume anything the state would be seeking to admit is going to meet a relevance threshold from there, whether playing the entire context of it would otherwise get over the hearsay issue. That I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context in recording. I will read the sample instruction to the parties. You also may propose any suggestions if it is admitted. But ultimately, it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of the defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You are not to consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses. That ultimately, if any will be admitted at all, that will be subject to that instruction.
I thought it was always up to the jury to decide whether or not the witness was telling the truth. To my knowledge, I've never heard an instruction given to the jury that they were not supposed to consider a witness truthful.
The jury, so it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. What? Last prong, autopsy photos.
So, Judge, the Florida Supreme Court has held that autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay? In this case, there is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I may be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 X-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But, Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that, again, I think it's a balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
No, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
we haven't done that in the past, but we're also we don't intend on attacking his credibility when it comes to how the murder was done.
So you may respond.
Judge, this is a material issue that state's required to prove that the victim is in fact dead. We don't have to accept a stipulation. The photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were x-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the stippling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Well, as to this point, I will find that the value of the autopsy photos are probative and the prejudicial effect does not outweigh them. The motion is denied as to this particular point. Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
I guess. I guess if you're a co-conspirator, that's what they tell the
I think
jury.
our motion, to some degree, speaks for itself. In this case, the state went to tremendous means to try to wait to arrest Mrs. Adelson until she tried to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in Florida. We were unable to find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again. I think we beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know, I'm far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity? In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases. There's a couple cases that I cited. And here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers about it. Okay? You're going to see that to make sure that she wasn't committing a crime. You're going to see that she used her own passport. You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to Mexico or fly to San Antonio, walk across the border, go. You're going to see that everything was pretty open and notorious, things that would contradict flight. And so, yes?
Does flight have to be surreptitious?
It doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances, when you're determining whether it goes to consciousness of guilt, flight is a component, right? If, for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight. When you look at the totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say 7, after she's a suspect. You see that she's traveled many, many times and always come back, right? So, and by the way, you hear phone calls. They're phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going, and what she's doing, right? And so, look, consciousness of guilt is a very, look, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions, but I'm here.
Well, is there any other evidence that puts context on this travel?
Is there any other evidence that puts context on this travel? I'm not sure I'm understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things that otherwise go to, this is not just the purchase of a flight?
Sure. There are pieces of evidence that I believe the state intends to try to admit that would show both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that. One moment. Yeah, I will. There is evidence of that for sure, but again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and what's the actor's name?
Harrison Ford.
Yeah, Harrison Ford, running around in Southeast Asia for the rest of their lives. But we think that when you do your balancing test, prejudice outweighs. We also say this, and this my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. That Vietnam villa is an investment done, as they know, they've spoken as their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it. That villa.
That's under the rules of Vietnam.
No, it's like a timeshare. So even when you own it, you can only live in it for 6 days. And so when Charlie Adelson is arrested, Donna Adelson and Harvey Adelson continue to make payments for that villa because that's the agreement they have with Scott Radius. And if not, they lost the prior payments. It leads to look. This consciousness of guilt argument leads to a lot of nonsense, to be honest with you. And we think that when you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it is allowed in, we'll probably ask for some sort of limiting instruction. But Judge, we think that it does fit, the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails. So.
Judge, there are just as many factors that suggest that this was, or flight was, a matter that was demonstrating consciousness of guilt as the ones that they plan to argue she was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. The state feels that's relevant. If it's anything that the defense wants to argue and the facts that they pointed out are they're fair game for cross-examination, they're free to elicit those, and we can have a dispute. Let the jury decide what the evidence shows and what the weight is rather than the admissibility. But how is it a 403 problem if she's just going on a vacation and that's what they're going to show? What's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
Right. As to this motion, I am prepared to rule. I review the cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. The motion is going to be denied. I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt. Really, it's not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that defense would seek, you may submit that concerning this issue. Right, I believe that covers the defense motions for today. Raj Rob, if you can submit orders, at least for the matters that have been ruled upon concerning these matters. Let's move to the state's motion in limine. As to prong 1, Ms. Kappelman.
Yes, Your Honor. As we have done previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts as irrelevant and bad character evidence. Did you want me to address prong 1?
Just prong 1 for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor. I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong 1?
Well, I mean, I think we're going to have to bring up the Latin Kings. I mean, they inserted it. We weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with the gang, did it not? It's just the name Latin Kings wasn't used?
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings is a relevant fact. That was actually inserted by the state in their bump operation, right? The whole point of the bump is someone's approaching Mrs. Adelson, who is supposedly also a member of the gang, and is speaking on behalf of Mr. Rivera, who wants to get paid, right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, what, how many rapes he's done,
So the name of the identifier, that is what you're seeking to make use of?
Of course.
Ms. Kappelman, response as to the use of the name of the group.
I do not agree that the name is in the evidence that the state intends to produce. If that's Your Honor's ruling, which we would request, then criminal street gang could be substituted for that.
Judge, we would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Ms. Adelson hears that the guy...
As one gang has greater credibility than the other?
It certainly does in Miami, right? So when Ms. Adelson hears that the Latin Kings are behind this, I mean, that's what she hears at some point, that's what the evidence is going to be, it affects how she does certain things, right? And so, we think that that is relevant, and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also, once again, permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve ruling as to that. Specifically, again, in what context beyond hearing she knew he was a gang member, or are you planning to use this or present this to the jury? Mr. Rashbaum.
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this was a particular chapter that...
What does he mean when he says she acted a certain way? Is he trying to say she was fleeing the country because it was the Latin Kings and she was afraid for herself? What? She acted a certain way. What is he talking about?
He was in charge of. Is that what you're getting at?
Correct.
Ms. Kappelman.
Judge, we just think it's prejudicial, more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin king. She knew there were gang members that were threatening to kill us, what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin king.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin Kings, I'm going to reserve on that issue from now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin Kings in it, we will approach.
Correct.
Thank you.
States, prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kappelman.
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred, so I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
Response?
We don't plan on doing this unless something crazy happens in court, and we'll approach the honor and we'll discuss that, but we don't plan on practically talking about that.
Very well. Prong 3 is granted. Counsel for defense is directed to alert the court should he believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor. We've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kappelman, you may make your argument.
Yes, Your Honor. The state has prepared demonstrative aids, which combine video footage, clarified audio recording, and transcripts into one item that we'd like to present to the jury for both the Dolce Vita recording as well as the Matsuri recording. Those are mentioned in paragraphs 4 and 6. We also have, similar to what we've used previously with the wiretap calls, slides that have the scrolling transcript along with a photo of who's speaking, which we think assists the jury in understanding those items of evidence. I think that was all that was covered in these. Yeah, so Dolce Vita, Matsuri, and the wire calls. We did previously have an objection to any editing, any underlining or any highlights, which we have removed from those exhibits. So those will not be present.
Well, response?
Our position is the same as in the last trial. We don't object to the transcripts from the wire. We do object to transcripts from Dolce Vita and Matsuri due to audibility. And last time I think the judge ruled with us and ruled that the transcripts would come in for the wire, but not for Dolce Vita or for Matsuri, and that's our position today as well.
I reviewed the recordings of both Dolce Vita and Matsuri once again. The issue that I keep coming back around to on this, Ms. Kappelman, is ultimately for a recording that does have some limitations or issues. How does the transcript not otherwise suggest to the person, or I should say, jurors who need to listen to and interpret it, what is on the recording if they themselves are not able to make it out clearly?
We do have, and had in the last trial as well, the authentication of the transcript by a party who was present for the conversation. I think that's what made the difference in reference to the Dolce transcript use in the last trial. We were able to use that. Matsuri was out. The defense is correct on that. That could potentially
Is that witness going to authenticate then the transcript itself?
Yes, Your Honor.
Mr. Rauschbaum, have any remaining arguments concerning it?
Yeah, you still can't hear tons of the transcript, and they're guessing as to words on tons of the transcript, and you still can't hear the first 31 minutes because they didn't record it. And they have a recording of those 31 minutes, but they didn't include it. So it should be, look, the standard is, in situations like this, you leave it up to the jury to hear what they hear. We're actually not moving to preclude the audio, we're precluding a transcript, right? I mean, the law is pretty clear that it's up to the jury to hear what they hear and make a decision based on that, and not what the state thinks they hear.
I agree with you, that aspect is clear. The additional portion of the witness who will swear that the transcript is authentic, what is your argument to that?
I mean, but every other word of the transcript is unintelligible. UI. So, I mean, that should not come in. You can hear some of those UIs. Sure, I can cross the witness, but do we really want to go through that when it's very easy that they just hear what they hear? That's the default.
Very well. This will be granted in part and denied in part. As to any transcript for Matsuri, which there is no authentication available by any witness, that transcript will not be presented to the jury. The jury is to determine for themselves what they believe the recording holds. As to any use of transcripts as a demonstrative with the wiretap calls, that will be permitted. As to the use of any transcript relating to Dolce Vita, that will be subject to a proper foundation and authentication being made by the witness. The defense may challenge the foundation and authentication by the witness. However, if the proper foundation is laid at that point, this is no longer guesswork as it relates to the transcript. The parts that are unintelligible cannot be misrepresented in any way. The witness may not misrepresent the parts that are unintelligible.
Yeah, I wondered that too. And with the kids, probably, because the whole reason they did this was so Donna could be with the kids. So, yeah, it makes sense that she would have followed with the kids so they could all be together.
However, to the extent the witness can say, this is what was said during the meeting, that is a proper foundation basis for that testimony, for that evidence to be presented to the jury. That is the ruling as to that item. All right, let's move on to states. Prong 8, statements to elicit sympathy for the defendant.
Yes, Your Honor. We had a prior hearing during the pendency of this case where some issues came to light regarding the defendant's allegations of how she was being treated at the jail. I've conferred with the defense on this. He's advised they do think that that type of reference and material would be admissible in this trial. As such, I would move to exclude any reference to the conditions in the jail as irrelevant under 401 and basically just being offered to inflame the sympathies or passions of the jury and more prejudicial than probative under 403.
What would this be offered for by the defense?
We don't plan on offering it. It depends, though, what comes up at trial, right? So, including consciousness of guilt, because it goes into why someone might do what she did to avoid being in jail, waiting a trial, right? So again, I don't plan on doing it. We don't plan on doing it openly, and we would come to you before we did it, but I didn't want to agree to it because I don't know what's going to come up at trial, right? So it's certainly not going to be something we do without notifying the court first, and I don't expect to do it.
Well, as an important proposition of law, jail sucks. However, why it would become relevant that jail sucks, that's really the question.
Again, as I stand here today, we don't plan on doing it. But if we think it becomes relevant, we'll certainly bring it to the court's attention before we do anything like it.
Very well. Prong 8 is going to be granted subject to any proper relevant basis in which this evidence could be examined upon. Counsel for defense, at the appropriate time, will need to raise why they think a relevant basis has occurred, and ultimately a proffer will be taken as a present to the jury. I think that takes us through everything for this morning, other than the other outstanding motion involving Sergeant Corbett. Are any other motions being anticipated by the defense or state concerning the exchange of witness list exhibits?
That did happen, Judge, and we are still in communication about small changes that are happening, and we'll bring it to your attention if we have any issues. But so far, we're getting along okay on exhibits and witnesses. There's still a couple depositions outstanding, which we're working on, so no issues to report at this time. We do want to approach on one other matter, though, before we are done for the day here.
All right. Mr. Morris?
Judge, on demonstratives, and when I say demonstratives, I want to make sure that I understand what you're talking about, you understand what I'm talking about. I've got some flowcharts or timelines that I'm constructing. They're not finished or complete yet, and importantly, I don't think they're going to be on Tuesday. I addressed that issue because that's the deadline that we've set. I addressed that issue with Ms. Kappelman yesterday. She indicated that she had similar timelines. We both agreed, with Your Honor's permission, that we're okay not being constrained by the deadline insofar as we share with one another prior to the trial. That way, if there are any issues, we're able to discuss those. In other words, no surprises. So the first thing I ask is for your permission to let us manage ourselves, I guess, to a degree. I think that we're in a good position to do that. What we're discussing as demonstratives are not contentious issues. They're not argumentative issues. I don't believe on the timeline issues. Second issue is because discovery, because of the depositions, there have been a couple of things that have come up. We're working through those in terms of whether there would be additional motions to eliminate. And when we approach, you'll have a better understanding of it. But that's basically where we're at. Everybody's working plain fine in the sandbox together, so to speak.
Very well. I would just ask for a status update on September 6th when we have the next hearing as to Sergeant Corbett's testimony and his presentation. It's not that I do not trust you all, but as I've found in the course of my many years on the bench, everyone's saying all is fine until all is not fine.
Sure.
We'll discuss it on September 6th. You may approach.
Okay. That's it for that hearing. That was a year ago. And tomorrow we'll finish up with Phil Spector at 8 in the morning. And then we will do another one of Donna's hearing. At one point, her attorneys are different, but I don't know if they're like the same law group or whatever. Or if she actually got different attorneys because there was a conflict of interest. At first, she waived it. She's like, I don't care if there's a conflict. And then I think she changed attorneys. But I have to do research, and I don't like research. That's why I have a Judy. And I wish that the Ali's were streaming. They're streaming, but they're streaming on somebody else's channel, and I think that they're getting it from Court TV, but I do not see a public link for that on Court TV. Mm-mm. Oh, they're just replaying the verdict. That's not what I want to watch. I watched that already. I want to watch this. Okay. Oh, well. If they make it public, I'll still stream it, even though I'm not able to do it live. Okay, guys. So we will try to finish up. I say try to finish up with Phil Spector in the morning at 8. And then we'll watch another Donna, I don't know why I can't say Donna and Adelson together wants to come out. Donald? Donna Adelson. We'll watch another one of her hearings tomorrow. So at least we have kind of an idea of what they're going to be talking about in the trial. And if I have time, I might watch some documentaries about it so I know a little bit more. So if you guys ask me questions, I can at least answer intelligently instead of, I don't know. Okay, guys. Thank you so much for being here. I got to fix the thumbnail for this so people don't get confused when they go from that current hearing to the one a year ago. Because I don't have a thumbnail up at all right now. And then I got to cook dinner for my hubby. So I will see you guys in the morning. Remember, be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys. Have a great evening. I will see you in the morning at 8 o'clock.